Good afternoon and welcome to Between Two FARS. My name is Warneke Miller and I am honored to be here today with Robert Tepfer, who is a veteran procurement attorney. He spent 22 years in the Air Force working procurement law and has then gone on to NASA, where he spent another 22 years, including 11 years as the team lead for procurement law here at Johnson Space Center. Bob, welcome.
Thank you.
I'm so glad to have you today. Could we talk a little bit about the different roles that attorneys take between contract litigation and contract formation?
Sure. I guess the first thing is most folks think that the creation phase is kind of an afterthought. It's fairly simple. You're a transactional attorney. The really hard part is litigating a case. The reality is that most of us, when we get out of law school, are intimately familiar with the rules of discovery, how to do depositions, interrogatories, or we can learn it fairly quickly. And the pleadings, they work themselves out. The fact of the matter is that's not the case. Creation is very complicated because the reality is you get a large amount of work thrown on your desk with regard to a 500-page document, and your job is to read the entire document, identify the issues, and figure out what the resolution, if any of them, are. That requires a lot of research, and it requires a lot of convincing people as to what the law is. So I always tell people that we're lucky with regard to the litigation because the issues are framed when we get the pleadings. We understand exactly what the problem is, and we simply have to go do research on a very focused issue. With regard to transactional work, you can't focus unless you can identify. So it becomes a case of going through it, knowing what the law is, knowing how the facts create legal issues, and then going to the client and explaining what the risk is. Any contract is essentially an allocation of risk. So, our job is not necessarily to tell them what the right answer is. Our job is to provide them options and explain the associated risk with those options. That can occur repeatedly and throughout the process with regard to creation of a contract, and it's very difficult to always be completely accurate and identify them all. And we also have a spectrum of issues with regard to the method of selection, whether or not it be a streamlined, focused primarily on performance, or a source evaluation board, which is a search for excellence, which requires a lot of paperwork and a lot of work with engineering to find the respective strengths and weaknesses. So I've always felt the creation phase is more complicated, puts you at more risk than the litigation phase.
I think the average layperson can understand an attorney's value in a litigation situation. What would you say is the attorney's value to the client during this formation process?
Well, there's actually two big things in my opinion. One is to identify the issues, but you're not really done at that point. Your job is to find solutions and provide a variety of them to get them where they need to be. You can't just say you've got a problem and this is why and give them the citations. You have to say this is a problem, but have you ever considered approaching it from this angle? Because what you're really trying to obtain is this service or this supply. And I think you'll get there through this method. There's a lot less risk and maybe even a lot less cost. If you do the creation phase, in my opinion, properly, you learn what the contracts people do and you realize the options that they have under the FAR.
So risk assessment and option analysis, and so from beginning to end of the contracting process, attorneys are important. I appreciate your time with us today, Bob. Please be with us and stay tuned for the next episode of Between Two FARS.
Thank you.